So anyways, my name is David. Nice to meet you all. Here's what we're going to talk about today. This is about raising capital, or at least having some capital for your startup. Let me just do one thing here. I can actually see this. Okay, cool. And so here's the agenda. What we're going to talk about. A little introduction. I just did that. We're going to do some challenges of raising capital and alternative methods to raise capital. We're going to talk about the applicable laws related to raising capital and securities laws and that kind of thing, and how one complies and what one should worry about. Then we're going to talk a bit about the security, whether it's convertible note, regular note, equity, common stock, preferred stock. We're going to talk about some of the kinds of issues that one negotiates with investors, whether it be preference or dividends or rights that they have, members of the board, control issues. So we'll talk a little bit about that. By the way, in security, we'll also talk about convertible debt, which is a safe notes, which is always a favorite. We'll talk about the top 10 or so mistakes that people make, and then questions and answers. But I really mean this last part, which is don't wait. If you have things you'd like to talk about, let's talk about it early on and talk about during the course of the thing. If I'm going to cover it later in much more detail, I may suggest that we sort of push it off. But I'd love to hear your questions along the way, because the last thing you want to do is sit and listen to me talk through the whole thing. So stop me if you'd like to. Before I get started, this is about raising capital for startups and how to position yourself for it. Are there things that maybe I didn't touch on that you want to make sure I do touch on during the course of this? And again, you should feel free to stop me. Okay. I just do one thing. Sorry, I'm playing with my computer here. Okay. So one of the things that I want to spend one moment and not a lot of time on is when you're raising capital, there's a balance. Because we're going to give equity to the investors, because they get something in exchange for their investment, which is fair. But we need to know that we're going to balance equity going forward. We only have 100%, right? That's all we have. If you give more than 100%, then you got to go to jail. So let's not do that. We only have 100%. We got a lot of people to share. We have the original founders who are entitled to something. We have the people that are going to grow this thing in the future, whether talent or management. We often create a management incentive plan. We'll talk a little bit about that further as we go along. We have ideas and innovators, people that are bringing the ideas to the deal, and we have the money, right? The investors. And you want to make sure that you've left enough equity along the road. For example, the people that are going to create value going forward. If I were to pick one of the mistakes I've seen the most in the last couple of years, it's people providing too much equity to people who aren't going to drive it forward. It didn't bring a huge amount of value to it, but more importantly, are not going to be a part of it going forward, and they have too big a piece, and that's not particularly helpful. So that's just something to think about as we think about allocating the money, the equity among the founders, and how much equity we give to the investors going forward. One of the other things I like to start with when we think about raising capital is, frankly, there's alternatives to raising other people's money. Other people's money costs. It costs equity, it costs time, you're reportable to them, they have rights. You're giving up a lot in order to do that. So I like to stop people in the beginning and say, are there other available sources of capital that are not dilutive, that you're not giving up a piece of the pie to other people? As examples, I've had clients that have done, used customers. You do a pilot test, you give them beta products, which then it converts into a later product and actually pay for it. So are there those kinds of things? Bootstrapping, can you do little pieces and do some sales up front, and then use those proceeds to keep growing the company? It takes longer, but maybe there's a lot less dilution, so maybe that's okay. So that's worth thinking about. Can you get some license fees? Public financing of grants, really important. You can look at SBIR grants, other public financing. They come with their own strings, but it's non-dilutive. They're not taking equity as part of that. So is that worth thinking about? frankly, if you have, maybe you can go to a bank and borrow it. Maybe you can, borrow. Now that's not always easy because there's not a whole lot of collateral for it. But are there some debt that that comes with its own risk? And we'll talk a little bit about that. And we'll talk about a crowdfunding, run a Kickstarter program, which again, may be non-dilutive. So the only point behind this is to at least consider, consider obtaining funding or financing this in some other way. People often come to me and they've already, there's this sort of this lockstep. I'm going to get angel money, then I'm going to get venture capital, and where I'm going to define these terms in a little bit, and then I'm going to go here and I'm going to do there, and therefore I'm going to and then I'll go public or sell. And you don't necessarily have to go lockstep in accordance with that. So just step back and think: do I really need this money, and are there other alternatives for it?
David, in terms of paid pilots as a source of funding, some of the other things you listed, they have sort of a prescribed procedure like SBIR grants and so on. There's a very detailed grant format, but on the paid pilots, I imagine there's practically an infinite number of ways you could structure those, but is that something that you've gotten involved from a legal perspective of actually crafting those kinds of agreements? And are there general sources that people can refer to look at the ways to be creative around that?
Yeah, so I'm not sure that I know anywhere to look. I mean, I've been involved with people where they have had customers essentially pay for a pilot, where they say, okay, I'm going to pay you to develop this program or this product. One that comes to mind is a voice recognition software program where the customer paid them to create the pilot. Obviously, the most important piece of this is making sure that, notwithstanding that they're paying for it, the company retains ownership and intellectual property in connection with that. Really essential, because if you don't own that, then there's really no point in doing it. It's actually a problem. But in exchange for that, the customer then has perhaps a better price on the product. Maybe they can get some exclusivity in their field. There's some other benefits you can give them in exchange for paying for that pilot or the product development. I think I interrupted somebody.
You have a question in chat. When we talk about equity and not giving, quote unquote, too much away, how does one know what is too much? Are there formulas that we can consider when doing an equity breakdown?
So it's a great question. And I wish I could give you a very precise answer, but I can't. I can give you some rules of thumb, and there's actually not very good at it. So the short answer is, go back to my first comment, which is you need to make sure that you have enough equity to permit you to do things like attract additional capital, make sure that your founders aren't so unduly diluted that they lose interest in the deal, and so. One way to think about this is just to give you some ballpark. If you're in one of the incubators around town, $50,000 plus incubator, maybe you give up. I'm going to make this up 5% or something like that to give you some kind of a thought process. If you're raising, a couple $100,000 in a startup company, and you're giving up more than, call it, 15% of the company, or then you're probably in a troubled land, because you're going to have trouble. You're going to get too far diluted down the road. So I'm not sure. Other people on the call may have some resources that have sort of a formula for this. I'm not sure that I have it. Let me do it another way, which is, often I never see, for example, in a first round venture capital. Again, I'll define that in a moment, where you're getting maybe $1 million or $2 million or $2 million. I never see in that round people give up control more than 50%. So, if you're gearing toward that direction. So as an example, if you're raising a friends and family, you should not be giving up control of the company, for example.
So David, I'm going to chime in here too. There is there's an exercise called Founders Equity Pie. So most of you are just starting out now. And so this is going to be how much do each of the founders get. And Frank Demler came up with it's a tool, it's a worksheet that gives you kind of not a formula, but a format for having the discussion. And he is going to be doing a Connect session on Thursday from 12:30 to 1:30. If you go on to the Short Center website or Olympus's, you can see it. They're free, they're open to everyone. It is taped. And actually on our Entrepreneurs Research section is a little write-up. It's a 4 or 5 page write-up with the template that you can use in order to work out, particularly at the initial founder level.
So that will help you. And Frank Demler's chart or system is not perfect, but it allows you to ask the right questions. It allows you to think about the relative contributions of the parties. That will help you vis-a-vis the founders allocating. It doesn't help you much on figuring out how much equity you give in exchange for capital going forward. And that's the other things I was doing. So another way to think about it is you might look around at some of the incubators, and I have some of the names up on the screen now, and see what they're getting in exchange for, in addition to their incubator and accelerator programs, they also provide some equity in exchange, and maybe get some guidance from that as well. Let me talk for one moment about the funding cycle. And by the way, I'm not checking the chat thing as I do this. So, Kit, if if you happen to see one,
I'm keeping my eye.
Please sure to yell at me. And again, other people, just interrupt me. Go on mute and go off mute and interrupt me. I want to run through the kinds of investors and the kinds of because you hear all these terms, and I'm not sure we're all sort of as familiar with them as we might be. An incubator is simply an organization that provides some services to the startup company in addition to equity. And there's some of those are listed there. LifeX is another one which is not on there. And as I said, they provide some services plus some capital usually. Then there's I call it the public or quasi-public funds like Innovation Works and Life Sciences Greenhouse, which go a step further and provide some very early stage money, usually in a convertible debt. We'll talk about that in a moment. Then you graduate a little bit from that, and then you have friends and family. Those are the people that you look around the table and you say, okay, who's going to help me get started with this company and give me some money for it? We're going to talk about how to structure that investment. Angels, I love the word angels. It's a great way to do it. But these are basically wealthy people who, in order to do this, individuals often who have experience in investing, who invest in startup companies, growth companies, entrepreneurial companies that they want to see a nice return on. And so those are called angels, high net worth individuals typically. Venture capitalists, then the next stage, and often people go through this direct. I mean, this is the way they do it. They go to friends and family, then they go to angels, and sometimes then to venture capital. And venture capitalists aren't all the same. There's sometimes early stage venture capitalists, and there's later stage. They have different tastes in how they like to get involved. And venture capitalists are typically funds that have been put together for the purpose of investing in starting startup companies, or I should say growth companies. They're distinguished by as I say, they're typically funds put together where these funds invest in a whole bunch of different investments, therefore diversifying the risk. Often pension funds or other kinds of investors are in there. And so that's a venture capital fund. And then similar to that are strategic investors, which are companies that might have a specific strategic interest in your company. In addition to putting money in, but they want some other benefit, whether it be they're a potential vendor to the company, the customer to the company. I have one now that's a significant customer to the company, and they actually want to put money in because they want to make sure that my client has sufficient resources to be able to support their business going forward. And so they want to put money into it. So that's a strategic investor. And the investment with them usually comes with some other strings, but that's okay. And then finally, the public markets, which you go to the IPO and you go to the public markets to raise capital. We're going to talk here a lot about the friends and family, angels, and early stage venture capitalists. Typically, this is what we're going to talk about, the way those are structured. Questions before I move on to different kind of investors? Okay. When you raise money from, this is not going to be for the lawyers. On the call. I'm not going to do an entire Securities Act lecture because it would be incredibly dull, and I wouldn't be able to hear myself over your snoring. But there is the Securities Act of 1933 that we need to make sure we comply with when we raise capital, and the issuance of any security. And a security is a broad term. I have the definition up on the screen, and you can see it's a very broad definition. Any stock, any bond, any convertible note, that's all a security. And as a general matter, under the Securities Act of 1933, the sale of securities requires that you register with the SEC, the registration of that security, that offering. And that is a large registration statement. It's like, many pages, very expensive. To do an IPO, to file a full registration statement is, well north of $1 million. And so nobody wants to do that. So how do we get around? So your sole objective is to avoid the registrations. And in order for that, you need an exemption from the registration. And we're going to talk about there are two exemptions that we're going to talk about specifically here. The one thing I want to note is while this is an exemption from that big registration statement I just referred to, it doesn't exempt you from two things. One is you still have to do a notice with the SEC when you comply with this. And that has to be filed, I think, within 15 days after the closing. So it's really important that be done. And two is it exempts you from fraud. So under the Securities Act. So if you defraud an investor, which is you fail to you tell them a misleading fact or you omit a material fact, then they can sue you for it for fraud under the Securities Act. So we've got to make sure we're honest with people. Shouldn't be that hard. And two is we provide the notice to the SEC. So what are those exemptions? And there's something called 506, and there's a B and a C, and we're going to talk about both of those. 506B, which has been around since forever. 506C, which is not for forever. And under 506B, you can offer to an unlimited number of accredited investors, and I'm going to give you a definition of that in a moment, up to 35 who you have a reasonable belief are not accredited. Here's the big definitions of accredited investors. There was just there was lots of discussion about revising this in a way that's helpful. They did revise it, but not in a way that's helpful. So, these rules still apply. You need somebody with a $1 million net worth, excluding their home, a couple $100,000 for the last 2 years, and expect the same thing for this year. If single, $300,000 if married, or an entity with $5 million worth of net worth of assets. So we can issue it to as many accredited investors as we want. There are some requirements for this exemption, and I want to spend a moment on this one because it's really important. You're not allowed to conduct a general solicitation. No advertising. No putting on your website. I'm seeking investors. No, putting on Facebook. I'm looking for investors. And you can't conduct any kind of general solicitation and qualify for that exemption. Really important. And you have to, believe that the person is not buying with the idea of resale. That's usually pretty easy. And again, I already talked about filing a Form D. So again, the sole point coming out of this is if you're relying on this exemption, you have to no advertising and file with the SEC. The little filing. Yes.
Dave, excuse me. This is Don Morrison. Can you expand on that for the entrepreneurs listening? There's a lot of business competitions, and at the end, some of the will sometimes say, we're looking for capital? Is there a line of which they should not cross? You know, at what point does it become public disclosure versus, you know, private?
Yeah, so the business competitions is a really good question, and one that is probably more more of a question than it should be. I think the position that people have taken is that in order to qualify to be in the business competition, the investors are basically self-qualifying, and so they're viewing that as not a general solicitation when you're participating in a business competition. And so that's the general view of that. But for example, but if you just, but I say just putting an advertisement on your website, not so much. But people usually, if you go to these things like these venture fairs, where people do a mini presentation, they people usually take the position that it's not a general solicitation because people are qualifying to get in there. I also caution people when you do that you can say we are looking for, and that maybe we will be open to investment, but I would not put any terms in that presentation because it looks more like if anybody did whine about it, you say, well, I wasn't advertising for it. I was simply describing the business as opposed to seeking investors. But that's.
So I would just also say they have a number of things like Demo Day, Alpha Lab Gear
Yes.
has them as well. And what to just say is like, everybody knows you're looking for money. You don't even have to
Correct.
say it.
Correct.
All you need to do is give a compelling business. Yeah.
Yeah.
So,
I prefer
one
not
of the things that Innovation Works has done to kind of get around that rule is they're now doing it as an invitation-only event.
Well, that's what I was mentioning. Yes.
Yeah,
Yes.
so
Where you
it's
call
not
it, they self-qualify. They qualify the participants so that it's not a public event.
Yeah.
Correct.
So if I'm an entrepreneur invited to pitch at a business competition, you might want to ask the organizers about public disclosure rules and how they protect the teams.
Correct. And online, they do some of the online things do the same thing. Do it the same way. The other way, Don, of doing it is using Rule 506C, which is if you only, and you're sure of it, have accredited investors, then the general solicitation no longer applies. And so many companies are now using 506C and saying, you know what, I'm only going to have accredited investors invest. And if you do that, then you don't have this issue anymore. It's gone. But the only problem with that is they have to all be accredited investors, and you got to take some extra steps to make sure they're accredited investors. And here's those, basically you got to make sure and there's heightened scrutiny. You got to make sure they're accredited investors. So one of the things that you all need to do as startup companies decide which one you're going to go for, 506B or 506C. If you're going to permit non-accredited investors, then you got to worry about the kinds of advertising solicitation that general solicitation we just talked about. If on the other hand, you're only going to permit accredited investors, then you can go solicit. You can put an ad in the Wall Street Journal for all I care. Maybe that's not the best source, but you get the idea. Don, did I answer your question? Your comment?
Yes. One of the issues with 506C, though, is a lot of wealthy individuals don't want to share or prove that they're accredited investors. So getting validation or verification can sometimes be problematic for the companies.
It can. I've actually not run into that much because you can also get accountants to verify it or something. You can get third-party verification. So sometimes you can get around it that way.
So David, we have a question in there from somebody wanted to know on the 506C, is that round by round or historically?
Round by round. Okay. Now, if they're too close together, if your round is too close together and you haven't, there's an integration question as to whether they're going to, the SEC would take the position that the rounds are integrated. But if they're like a year apart and they're significantly different securities, then they should not be integrated, and it's a round by round test. Good question. It's a really good question. Other questions? And one of the weird things is that don't forget about the states. We live in this lovely country where we have federal government and state governments, and each state has securities laws. So the good news is that most states, if you comply with Reg D that we just talked about, 506 B or C, then complying with the state law is fairly easy. You just do a notice to them, and you pay their fee because they got to get their money out of it. But you got to make sure you do it. So you got to make sure you comply with those two. And the state that you care about is the state in which the offer is made or the sale is made. So if you have an investor in Nebraska, then I got to worry about Nebraska law. If so it's you got to pay attention to what state your investors are in, and you got to comply with those state laws. But check with your lawyer when you're doing this, because some states are a little tricky. Like New York has a registration requirement because they register this. It's a long story, but the short answer is that you got to file in New York before you even make the offer. So check with your lawyer before you start making offers. So the bottom line is pay attention to the securities law. Know upfront whether we're going to make it 506B or 506C, because you want to make sure that decision early, because you'll make decisions as to whether or not you're advertising. Okay. So I often get the question of who cares. I'm doing a little. I'm doing this little offering. I just can't be buying. I mean, it's like if I cheat on my taxes, who cares? And that's a fair question, by the way, because it seems like a lot of rigmarole. So why do I care? And there's really there's a practical answer. And the practical answer is that you see Homer there with the two people on the shoulder, the devil and the angel. And you can decide which is which. But think of it as the purchaser and the investor. And you're going to have to make representations to these folks, both a purchaser and an investor, that you're in compliance with all applicable laws. And they're going to want to see that you are in compliance with all applicable laws, including securities laws. And if you're not, then you may not get that investment, or you may not get that acquisition. So as a practical matter, this is, putting aside the risk, which I'll talk about in a moment, as a practical matter, you can actually adversely affect your company and the very thing you're concerned about, which is a capital raise or a sale, if you don't comply with these. So to me, that's the biggest practical issue. In addition to that, if a investor is unhappy, and they find that you did not comply with this, they actually have rescission rights. So they have a right to say, give me my money back, which is not particularly helpful at all. And if you comply with these, then that's a bit of your insurance policy. Then they can't sue you for it, which is also helpful. So it's worth paying attention to. And I'm putting it, so that's that. When you're offering people, you got to tell them what the hell they're buying. There's a disclosure requirement. In these things, there's actually no requirement that you hand people a private placement memorandum, big fancy thing. So, but I want you to think about, what am I giving the investors so that they can't claim later that I didn't tell them about what's going on, or we told them something misleading, right? Those are the big things. You want them to know what they're getting into. And so, I don't care whether we do a whole private placement memorandum. Sometimes I do they give them a business plan and a bunch of disclaimers, or risk factors where they understand the risk associated with this, because it is very risky. I hate to say this, but many businesses don't succeed. And they need to understand this. Here's a list of the things that are usually in a private placement memorandum, but the ones I really want to make sure that we talk about to the buyer, to the investor, is the risks associated with it and the conflicts of interest. The extent that you guys are collecting fees, or you're collecting wages, or you have, you know, other arrangements, or turns out you're the landlord with this thing, and so you're making money on that side. I mean, we need to disclose that. It's all fine as long as we disclose it. Our system is about buyer beware, but our job is to make sure we told them everything we know. Then it's up to them whether they invest it. That's the way the system works.
Yeah, there's been a couple very public ones. I think it was Blue Apron that
Yep.
the investors went after them, and it was tabloid information all over the place. So
Yep. Yep.
Go just Google that, and you'll see what. Well, if you don't do what David's been saying, what can happen.
Yeah. I mean, it's not. I mean, there's nothing like when a client, and you know, and things just, sometimes things take longer. Sometimes they need additional capital. Sometimes pandemics happens. I mean, all kinds of things happen, right? And if you can look to the piece of paper and say, "Look, I told you right here that this is what could happen," they don't have a leg to stand on. That they took that risk. All right. Questions on sort of the securities law. I promise I won't talk about the securities law anymore, unless you have questions on it. Yeah, I'm not going to spend any time on this, but I mentioned earlier about raising capital in another way. Crowdfunding is a nice way, and this is not what I'm not talking about here is raising cash through investors through crowdfunding. That's a no-no. But there's a whole system which really doesn't work for that, so put that aside. But what this is the Kickstarter program, where people go into Kickstarter, you offer something to people, or basically they buy products or services. They contributed, as a matter of fact, and in exchange for which you raise capital. So it's not really an investment. They're not getting equity in exchange for that. That's my word security. This is not the security. So the one I have up there now is a company called Thread, which is a wonderful Pittsburgh-based company that takes material or actually recycled material out of Haiti and creates products here in Pittsburgh, actually in Homewood, where they have a facility. These are backpacks that they made. And so when they started this product, they did a Kickstarter program where you went and ordered all these backpacks. You made a contribution or donation. You got in exchange for that, you got a backpack when it was ready. They took the proceeds, could then use that to acquire the inventory and make the products and do it. So that's an interesting way to fund it. Similar. Here's one where this is another Pittsburgh-based company, Shell Games, which wanted to figure out both sort of fund a new product, a game, a puzzle game. So they did the same thing. They gave people certain rights, certain rights to the game or copies of the game, and they made a contribution. I think I have one more example too. Nope, I took it out. So that's it. That's just something worth thinking about, non-dilutive.
One of the things that entrepreneurs need to be aware of with Kickstarter campaigns is there's usually a requirement. If you take deposits on the product, there's an obligation to perform within a certain set of time, 90 days or whatever. So just be aware of when you have to deliver.
Agreed. Yep. Okay. Let me move on to, unless somebody has something else they want to talk about before then, the type of security. When we give to investors, what we're giving them, huh? And the world is carved into two pieces: debt and equity. And what you see there is sort of the I'll call it the hierarchy of repayment. If one went into bankruptcy, the deal fell apart, who would get what money in what order, right? At the very top is secured debt. That's debt that you say, okay, I'm going to pay you back, and it's secured with like a mortgage or a security interest in the receivables or something, and it says, okay, that's paid first. Second is unsecured debt. So it's not secured by anything, but it's an obligation to pay debt, but it's not secured by anything. So that's sort of right below the secured debt comes unsecured debt. Let me go to the bottom. common equity. They're the last ones to get. So for example, if you're the founder and you have common stock, if there's, you're at the very bottom of the totem pole. After everybody else gets paid, you get paid. Above you is the preferred equity. We're going to talk about preferences and why, and preference upon liquidation, they get money out first. So that's preferred equity. We're going to talk about preference in a little bit here. And right smack in the middle is convertible debt, which is debt, which then can be converted to equity. And we're going to talk about why that's attractive or unattractive, depending on your point of view in just a moment. So those are the kind of securities: debt, equity, and convertible debt, which goes from debt into equity under the right circumstances that we'll talk about. You can go out and borrow money. It's not always easy, but you can borrow it. And it has a benefit to you. The benefit is that when you borrow money, there's a maturity date, so you got to pay it back at a date certain. It's very simple. You pay X dollars. So if I borrow $100,000, I got to pay back the $100,000. The good news is non-dilutive, so they don't get any upside. They only get $100,000 back plus interest. So if the thing becomes the next Google, that's too bad. They got the $100,000 plus their interest. It doesn't require valuation of the company. It doesn't matter what the value of the company is because they're getting their $100,000 back. The downside is it has to be paid back. And who the hell wants to do that? If the company doesn't go well, that's not what you want to do. And it bears interest. So that's not as good. And you have this big debt on your balance sheet, which makes it unattractive to other people. From an investor's perspective, they don't typically love it because there's no upside. I mean, you're lending money to a company that has that has relatively little track record, if any. You're taking all the risk and you're not getting the upside. So who wants that? So from an investor perspective, they don't usually love it. So it's not really a perfect vehicle. But short term, if somebody wants to just come in and lend you a couple dollars to get this started, and then friends and family, and that's a vehicle to do it, right? Sometimes people want collateral for that. If they'll say, okay, well, I'll lend you X dollars, but I want you personally to sign on it. And that's personal guarantees, of course, is one of the things I don't love, because while you're willing to put your time, energy, and money into this, you may not want to put your entire net worth, or worse, your significant other's net worth on this thing, the house or otherwise. So that's so personal guarantees are something to pay a lot of attention to, so beware of that. But then somebody may ask for that, or they may ask for a security interest. For example, whatever, some other assets. You have a CD, pledge the CD as collateral for it. But that's an approach. That's something at least worth at least know what's out there. I don't typically see that in the startup phase because, again, there's no upside for the investor, and there's no assurance of payment. But it's worth sometimes people do it as a short-term basis for friends and family who just want to lend them the money. And by the way, I should say the best way to have a personal guarantee on that, the worst way, depending on your perspective, is sometimes people borrow money from friends, family, and then put the money in. So I'll borrow $100,000 from Uncle Joe. I owe Uncle Joe personally $100,000. I put the money into the new company. Now, if the company goes bankrupt, I still owe Uncle Joe $100,000. That's the functional equivalent of a personal guarantee. So just be aware of that as well. So that's alternative one. Just borrow the money. Not typical for a startup company. The second one is common equity. You could just if you're a corporation and you have common shares, I'm just going to issue common shares. So if somebody wants 10% of the company in exchange for $100,000, I give them 10% of the common interest. It's really straightforward. It is amazingly straightforward. It aligns our interests because when I make money, my investor makes money. So it's really straightforward. It's easy. There's two things about that that's not perfect. One is it requires evaluation. You'll see in convertible debt, we don't need evaluation. And two is because it doesn't have some of the preferences, some of the benefits of a preferred stock that we're going to talk about in a moment, the valuation is lower. So sometimes it's a lower valuation, which means you're giving up more equity, lower valuation, lower price, higher dilution. So it tends to be more expensive to give common, and as I say, and it requires evaluation. So sometimes people do this. Again, friends and family will say, well, you just give them, a common stock. It's relatively easy, which is nice. So this is not uncommon. When you have a friends and family around, you just want to give up, let's say they give you, X dollars to get started, you give them common interest, and it has the benefit of aligning interest, and it's really straightforward. So that's not uncommon to give common, not to pun. Okay, I think we already talked about that. Then there's preferred stock. And this is probably the most common, so preferred stock, at least for venture capitalists. And at this point, in my experience at the moment, angels as well often have preferred stock. It gets a liquidation preference, and I'm going to spend a moment on liquidation preference in a moment, so I'm going to pause there, but that's the most distinguishing feature is a liquidation preference, which is why I'm going to spend more time on it. It typically accrues a dividend, and it's, that could be as little as 4%, it can be as high as I've seen it 12%. And it accrues a dividend. Now, as I say, there's not your Disney type dividend, which means that every quarter you get a little check from Disney with Mickey Mouse on it. That's a different kind of dividend. This says that you will accrue a dividend, an amount equal to the dividend rate per annum every year, and that will be paid either in cash or in stock upon a sale of the company or a liquidation event, which we're going to talk about. So what that ends up doing is meaning more dilution. To take it as its most simple, if it's 10% dividend and you have it for 5 years, that's a 50%, assuming not 50% additional dilution, or that you've taken or you owe that investor. Really important. So that's fairly typical. So you negotiate really hard what that dividend rate is, right? I'll talk about controls in a moment. The downside of this is, again, it requires evaluation. You got to figure out how much stock you're going to give people for this. What is the valuation? If you're going to take $1 million and it's how much of the company you're going to give up, and that's called the pre-money valuation. Again, we'll talk about that a little bit more in a moment. And it may not, because of the liquidation preference, it may not align interest. They may have an interest in selling before you do, because they get their money out first. Let me just talk for a moment about what the liquidation preference. Preferred stock, as I mentioned, the most distinguishing feature of preferred stock is that it gets a preference. So upon a liquidation, and a liquidation, I know that sounds like a dissolution. It means like we're going out of business, but it's pretty broadly defined. It could mean a sale of the company. It could mean a sale of all or substantial of the assets. It could be a merger of the company. So if you merge into another company, that would be a liquidation typically. So upon that kind of a transaction, a significant transaction for the company, then the investor gets a preference. So generally what that means is they get their money, plus that accrued dividend I just mentioned. They get their money out first. Okay, really important. So that's downside protection. So if they put $1 million in and we sell it for $1 million, they get their $1 million, we get nothing, right? It's downside protection. So so that's the principal reason, the purpose of it. But actually, the participation really comes in what I call two flavors. There's participating preferred and non-participating preferred. And I promise I'll do an example of this in a moment so that it's better understood. But participating preferred means that the investor gets their money back, plus they share in the proceeds thereafter on a pro rata share. So for example, if an investor puts in $2 million and they get 40% of the company, they get their $2 million back, plus they get 40% of everything that's left over after the $2 million. That's called participating preferred. So that's more than just downside protection. They're actually getting an enhanced return on their money. because they're getting their money back plus their dividend plus their percentage, participating preferred. Non-participating preferred is where the investor gets the greater of the amount they put in plus the dividend, or the amount that they would get if they got the pro rata share. So for example, by my example, if an investor put in $2 million, they would get, and they got 40% of the company, they would get the greater of their $2 million plus dividend back, or 40% of the proceeds. Participating preferred versus non-participating preferred. Now let me pause here. This is a it's really interesting because you will see in term sheets these kinds of terms, and it's really important that we understand these when we negotiate these term sheets. And this is just one example of what's in those term sheets that difference can be very material to you going forward. And so I can't urge. There's nothing worse for me as a lawyer on behalf of a new client when somebody comes to me and says, I've negotiated the term sheet, here it is, so write it up.
David, we have a question. Is the participating versus non-participating negotiated in the agreement? Is this the non-light versus the light version of preferred, respectively?
So so it is negotiated on the term sheet, and it is negotiable. And the light versus non-light, you will get into this on both, any kind of preferred. You'll get into this question. It's not distinguished between those two. You will always get into this question whether it's participating versus non-participating, and so that's the answer. But my point was that I'm going to make a push here for consulting with lawyers early, because these kinds of concepts are in the term sheet, and if it's not negotiated then, you can't, it's difficult to open it up again. So sometimes venture capitalists will say, well, that's a business term. Well, it is a business term, but you know, the founder is in the business of, they're in the business of whatever technology they're doing. They're not in the business of doing term sheets on venture capital. And so these terms can sneak up on you. So I'm recommending to you that you have a lawyer help you with these term sheets from day one. And this is a perfect example of that, which is why I'm pausing and hammering on this almost obnoxiously so. Or Kit would tell me not even close to obnoxiously, just obnoxiously so. So let me give you an example of the preference, just to give you some example of this. If you had a $2 million investment and there was a $3 million pre-money valuation, and a pre-money valuation is the value of the company before the investment. That's why it's pre-money valuation. And the technical way you do it is you figure, okay, what's the valuation divided by the number of shares, and that's the price per share. And so let me give you, so let's assume for the moment that there was a pre-money valuation of $3 million, $2 million investment. That would mean that the venture capitalists would get 40% of the company, and the founders would have 60%. Let's just do an example here. So at a $2 million sale, they're both participating preferred and non-participating preferred. They're still going to get the $2 million out first. So the venture capitalists walked away with nothing. With $2 million, the common got nothing. Suppose there were a $5 million sale. On the participating preferred, the venture capitalist would get his $2 million, his or her, their $2 million plus 40%, because they have 40% of the difference. So they get the first $2 million plus 40% of the remaining $3 million. So that, you see the red, the 3.2, they would get $3.2 million. Founders would get 1.8. Let me just contrast that with the non-participating, which they would get the venture capitalists get the greater of 40% or $2 million, $2 million their investment, or 40%, which happens to be the same number, $2 million, bad example, but $2 million. Contrast, The participating preferred, the venture capitalist got $3.2 million. The non-participating preferred, they got $2 million. Or flip it, the founders got $3 million in one example and $1.8 million in the other example. That's real money. So that's the point. All right, I've beat that to death. The last type of security I want to talk about is convertible debt. And I better start moving quicker because I'm going to run out of time. And convertible debt is a hybrid. So it's you borrow money from somebody, and it converts to equity, typically at the next round of funding. So I borrow money from somebody, and it says, okay, at the next round, when I actually do raise real money, it will convert into equity, typically at a discount to that valuation because I took more risk. So if I raise, I borrow $1 million in convertible debt. At the next round, that $1 million will convert to preferred stock at a discount because again, I took they took the risk of coming in early. Usually, typical discount is like 20%. Sometimes it's based upon when it happened, but it's some discount as negotiated. I want to leave in the bold here. It's kind of cool. You guys can see me doing this. Is the cap on valuation sometimes negotiated, and it's much more common now than it used to be, is that investors will negotiate a cap on that valuation and say, okay, you know what, that's all right, but I'm going to cap the valuation for the next round, which means that notwithstanding what the new investor invests at, the valuation for purposes of my convertible debt can't exceed X dollars. And that's because they want to be protected against the venture capitalists coming in or somebody coming in and using a crazily, unreasonably high valuation, which they will be subject to. So sometimes you have that negotiation. I don't love that, but sometimes that's the case. I don't love it on behalf of the companies. What's the benefit of this convertible debt? One is it's common. I mean, it's easy, it's very common to do it. Two is it sort of avoids the valuation question. I don't have to have the discussion with the venture capitalists and the investors as to how much of the company they're getting, because we're going to push that off till another day. We're going to get they're going to get a discount to the next round. So we'll worry about the valuation at the next round. That makes it a much easier negotiation. The reason I have sort of is because if we're going to discuss the cap on the valuation, then I still got to have a valuation question. Or what's that cap going to be? But that's a little different than what the valuation is today. So that's kind of that's pretty good. Downside, you don't know what that conversion price is going to be. So it could be quite significant. I mean, or not. So for the investor, they don't know what that's going to be. That's a risk. And you don't know what's going to be. Usually it accrues interest, which is additional dilution. It's not the end of the world if you can negotiate that down to a decent number. And importantly, debt holders have an interest that are different. I mean, if they're on your board, et cetera, obviously when you go to raise the next round, they actually have an interest in that valuation being low because they'll get more equity when it converts. So their interest is actually quite different than that of the common. So you just have to be aware of this. Not the end of the world, but just one needs to be aware of it. It is, let's get this. Let me go through an example, if I can, of this, just to give you some sense of it. Of a priced round. Suppose the founder has, 1 million shares, owns 100%. That's pretty easy. Even I can do that math. And then we create an employee pool, 15%, issue them at 176,000. They have 15%. That's fairly common. Create a pool of 15%. And let's raise a family round of $250,000 at a $1 million pre-money valuation. Remember, that's the value before the money comes in. So we take the number of shares, divide 1 million, divided by a valuation by 1,176 shares. That's 85 cents a share. The friends and family gets 294,118 shares, 20% of the company, which makes sense because they end up with anyway. They end up with 20% of the company. Now let's suppose we get a $2 million investment at a $3 million valuation. So this is the VC example. VC comes in now. They get another 40% of the company, and so that's the cap table. All right, just hang with me for 1 second. Let me now do an example of convertible debt. Same scenario, $1 million founder, employees put in 176,000. We're going to use $250,000 of convertible debt this time instead of a priced round. Same thing, $2 million investment, $3 million pre-money valuation. Same thing, but now we're going to do convertible debt. Because the convertible debt then came in at a discount to the next round, which ended up being a higher price, you'll see that the friends and family now, that round in the convertible debt only got 6% as opposed to 12%, and our founder ended up with a much higher percentage. Right? It's not always the case, but my point is that sometimes it's a better deal if they have convertible debt because the valuation may be significantly higher on the next round, and so you end up with more money. Not always, but it's worth at least thinking about.
I don't know when to interrupt it on this one, David. You
That's
might
good.
want to table it. But aside from negotiating against a valuation cap, if the investor is requiring it or they won't give you money, how best to determine it? Does this just come down to throwing darts? It seems unreasonable to spend money to set the valuation cap.
Yeah, so that's a good question. And I think what you want to do there is, there is nothing to be done other than negotiate it. But I take the position that it should be a relatively high number, which is it is protection for them against a schlemiel, somebody coming in doing it a crazy evaluation. And so I tell them that this is not intended to be a valuation today. This is intended to be a valuation tomorrow because you're getting the discount. And so we're going to pick some high number and we'll use that as your protection. It's the best negotiating thing I've got. Okay.
Yep, he said so. Fine.
Cool. Okay. I want to caution that convertible debt can be painless coming in. I always say it's a little like drugs because it feels really good, but you can OD on it because there's no valuation and you haven't given up any dilution because it's just on the balance sheet as debt, but you can have too much. And here's an example. You take $1 million of friends and family, convertible debt, 20% discount. And then you go to the next round of $2 million and a $3 million pre-money valuation. And just there's the numbers, but notice our examples before where the founder had 41% and 46%, and now it's down to 30% because it took too much debt. And I've had convertible debt as much as $14, $15 million, and way too much. And so you got to be really careful if you burden it with too much debt. But you see lots, and I do want to emphasize, you see lots of convertible debt out there. It's not a bad vehicle to start up companies. It's a little more straightforward. Places like Innovation Works and others use it all the time, and it's a nice vehicle, and one that we need to get comfortable with. People also use safe notes. It's short for simple agreement for future equity, and it's sort of a quasi convertible note. Because people give you money and it's converted at the next round at a discount. It's only paid. If you sell the company before then, it's paid or converted. It's paid before any equity gets any money. But the odd thing about this is there's no maturity. Unlike a convertible note, which actually has a maturity date, so you got to pay it if it hasn't converted. Here, there's no maturity. So if nothing happens, there's no obligation to pay.
But David, I also thought that they didn't have interest as well. Or is that?
They can. They sometimes do.
They do. Okay. Is it typical?
For me, yes. Yeah.
Okay. Okay.
Yep. All right. That's the type of security. The next area that I find people spend a lot of time negotiating is control issues. And investors like to say things like, I just want to seat the table. I find it very useful to think about control issues as I call it the 3 layers of influence. And one is the ability to cause something to happen. In other words, the company say they reserve the right to cause the company to be sold, or cause the company to raise additional capital. I mean, that's the the highest level of control of influence, right? They can cause something to happen. The second is the right to block something, a veto right. So if, many times an investor will can maintain the right to veto a sale of the company, the right to raise additional capital. That's a veto right. And the third layer is simply a right to participate in the discussion, neither a veto nor a right to cause, but it's a right to at least be at the table to negotiate it, like a board seat. One board seat out of many. So the board member is there when a decision is made, but can be outvoted. So when you're negotiating these kinds of provisions, and this will come in the context of both many term sheets you will see, the investor maintains certain rights, and it will be either representation on the board, how many board seats there are. It will be on the preferred, the stock having veto rights over certain transactions. I want you to think about these layers. Are they asking for the right to cause something to happen? Are they having a right to veto it, or are they having a right to just be at the table when it's made? A really useful tool to think about. Many investors want a seat on the board going forward, especially if you're in the venture capital role. So that's not unusual. The question is who's going to, how many seats are they going to get? If you're in the second round, often what they'll say is, okay, we'll create a board of 5, 2 by the common, 2 by the preferred, and maybe an outside investor or whatever. So, an outside, an independent board member. But it's important to see how that control is going to take place. So,
David, I have a question. How often do you see some of those types of issues addressed in the corporate organizational docs? In other words, sometimes within organizational docs, you can specify whether you need a majority of shareholders to vote for certain things to happen and a supermajority for other things to happen. Or is this more often in the specific term sheets?
Right, it's typically in the term sheet, which then gets memorialized in the ultimate the corporate documentation. You would typically have in the term sheet, as an example for a venture capitalist, it will say that they want a separate veto right. They won't use that word, but I'll use it, over, for example, a sale of the company or a liquidity event or a next round financing. And that'll be in the term sheet, which then will morph into be memorialized in the documentation, the corporate documents. And the sale of the company is a perfect example where I've told the story before about the company. We didn't represent them. I just happened to represent somebody at the last minute. But they, an early investor had a veto right over the sale. Did exercise that right, vetoed the sale of the company. Everybody else thought it was time to sell, and they ended up paying that early investor a lot of money to make that right go away. I always say if you have to ask for permission, it's a euphemism for how much. And so they end up paying for it. So it's not uncommon, but it's an important provision. Similarly, giving investors the right to approve the next round of financing. Again, it's not uncommon, but it's something to be thought about, and you got to pay attention to who your investor is, because there's been several cases in which investors sort of exploited that opportunity and drove down the price said no in order to drive down the price so they could invest at a low value and take over the company. I'm not saying that's always the case, but you just got to be careful. So those are the kinds of things that you want to be careful of when negotiating control issues.
I will just make one comment on observer, because I had one of our companies that had this. They thought, oh, this is easy. They don't have a vote. Turns out, but just because they don't vote doesn't mean they can't talk.
Yes.
And they can be very, perhaps obnoxious, very driving, very influential. So.
Yeah, I have had observers take over board meetings, to be really blunt, by pure force of personality, and you would never know they weren't a voting member from the way. They almost looked like they were chair of the board and running the meeting. So that is your point is very well taken, Kit. I will also say that it's very common for people to negotiate observer rights. I mean, it's not that uncommon. Some of the things you need to worry about are confidentiality, because they're not subject to the same fiduciary duties that board members are. Actually, they have no fiduciary duty unless you negotiate something. So you got to worry about attorney-client privilege and confidentiality and those kinds of things. And when it ends, it's one thing to do it. You want to make sure that that right ends perhaps at the next round or something like that, because that's a problem. But I agree. That's a very long-winded way of saying I agree that I've seen it happen. I've also seen, by the way, I should say on the other side, I've seen observers be very constructive and helpful at board meetings, helping through some difficult issues. So it's really, board member dependent.
David, in terms of that overwhelming observer, are there any tips in terms of how to manage it other than push back with your personality?
Yeah, that's a really good question. A gag, usually, sort of gagging them usually doesn't work. Yeah, the answer is a couplefold. One is to be careful in who they can appoint in the first place. So, I mean, the important thing is to know who they're going to appoint before you. I mean, sometimes you actually say this specific individual. So, and you get comfortable with who that is in your due diligence in the first instance, because there may be, I've had situations where there was a venture capital or a private equity fund who, there were 3 people around the room and we know 2 of them we didn't want, right? So we actually identified which individual it is. So the best solution to this is to identify who it is in the first instance and identify that person. And you can sell it as that we think that person has a lot to contribute and blah, blah, blah. So that's the best way to do it.
Okay, thanks.
This other ways to address it are, that's pretty hard once they're in to get rid of them, frankly.
A question. So sometimes the founders also become board members, but then they are not the significant investors in the boardroom, even though they're part of the board. So the control, even maybe they have seats, but they don't have the same way of voice in the board. What would you advise those founders to increase their controls?
What's that? So, I mean, it's a good question, which is the role of the founder in the boardroom, right? I mean, sort of
Right.
what's their and typically you will find that sometimes the venture capitalists who are in the boardroom have a little more experience and they're a little more I'll say assertive in their views, right? And I do want to emphasize how important it is for founders to listen, but it's their company. And venture capitalists, and I'm not at all anti-venture capitalists or insulting them, but you know what? They don't live, breathe, wake up in the morning worrying about your business. It's your call. And sometimes they have sort of not a knee-jerk way overstates it, but the point is that they don't have the same perspective as you do. And so, as long as, I would try to be assertive and persuade them of the way you see it. That's sort of one way to think about it. And so it's important to be respectful of their money because they put money into this thing. And that's always to respect that. But I also think it's really important to remember that it's your business and you know more about it than anybody else does. And you need to always remember that and be assertive on your view if you disagree with them. I've seen too many times where entrepreneurs felt afterward that they wished they had not listened to the VC, or at least taken their advice, or not argued back, right? And the classic being wanting to dump lots of money into like advertising or something like that, and use up the money really fast and go really splash. And maybe that's not the right approach. So I'm not being negative toward the money. I respect their money. I respect their advice. I respect the fact that they've been through lots of companies. I also respect the fact that this is your company and you're spending all the time on it. So listen, have an open mind. But at the end of the day, if you think it's the wrong decision, push really hard for it.
To that point, David, one of the pieces of advice I give all entrepreneurs is that in all things, choose your partners wisely.
Yes.
And that especially applies towards financial partners or investors. You know, you don't necessarily want to take money from the first one who says yes. You want to find investors whose interests are best aligned with your interests, and makes a big difference.
Totally agreed. Totally agreed. Whether that be the investment horizon, or others, even sometimes down to the personality mix, right? I mean, there's just some people you're going to get along with, and it's going to be more constructive. Totally agree. Totally agree.
Well, can I ask one more question?
Take two.
So I saw some shareholder agreements gives the founders the preferred stock, but some takes the common stock. What's the difference between those two options for founders? What's the consequence? Yeah,
I mean, it's I mean, obviously the founder having preferred stock puts them on a better position upon a liquidity event or or a sale of the company. They're getting some money out faster or better, or, you know, on the same terms as the investor, or perhaps at least as better than the management, perhaps, who are getting options in common stock. It's fairly uncommon, at least in my experience, for founders to have common stock. I mean, a preferred stock. They typically would have common stock. The place that it is the exception to that is when the founder is putting money in later. And so if they're putting money in, they'll do it on a pari passu basis with the investors. So if you know, the investors are putting money in and the founder's actually putting some money in, they'll typically put it on, you know, they'll often put it in the same terms as the investor. But as far as the founder stock or equity in exchange for services, that's typically common stock.
what is it when people say it's diluted or non-dilutable? How does it related to this common stock or preferred stock?
Well, when you take in additional capital and you issue additional stock, both preferred and common are going to get diluted. You know, if I issue, you know, 20% more stock, we're all going to get diluted by 20%, right? It's just the natural of the pie's not getting bigger, so we're going to get a lower percentage of the company. I own a lower percentage of the company. Okay, so they're both going to get diluted. There's the thing that's on the screen now talks about anti-dilution protection, and that is a different concept, and that goes to price protection. And while I'm not going to spend a lot of time on that here, sometimes investors get what's called anti-dilution protection, but it's really price protection, which is if I invest at $1 a share, and you go and issue, the company then issues a whole bunch of stock at a lower price, I get some protection for that. And because if you issue a whole bunch of shares, the company issues a whole bunch of shares, let's say at a dime a share, then I feel like an idiot because I just put it in $1 a share, and we're issuing a whole bunch of shares at a dime a share. So there's some mechanisms. It's called anti-dilution protection, price protection, to protect the investor against that. And that's what that's referring to. And sometimes investors get that, and there's weighted average, and there's full ratchet, and all different things that we can talk about. But the point is that's a protection that they get as well. If you're the founder and you have preferred stock, you'll get some of that protection. As a common shareholder, you're not going to get that.
Thank you.
Mm-hmm. I'm going to run out of time, so let me skip this and go to the top 10 or so mistakes that I see people making when they raise capital. I don't know why I didn't have so many references to Homer on this thing. I must have been in that kind of mood when I did this. The first is overpromise and undeliver. You know, it's important. I mean, I get that you want to go investors, you want to promise the world, you want to explain the whole thing, the hockey stick and the whole thing. But it's, you know, when things don't go well, the first thing people do, the investors do, is they pull out the projections, they pull out the promises, and they say, you said you would do this and you didn't do that. So I don't believe in over promising and under delivering. I believe in being realistic in your projections and what you're telling investors. Ranges are good. I find that this is the one place I like ranges. You know, it could be as little as this, as much as this, but it's really important to be realistic. Number two is early money is the most expensive money. And so don't waste money. When you get investment money in the company, you're flush with cash. Treat it, use it in a smart way, in a way that's actually going to create value. Don't go crazy with it. Three is disrespect capital. Don't disrespect capital. I've seen people, you know, I mean, you've put your life into this thing. You've really worked hard at this. Sometimes it gets kind of easy to say, well, all they did was put money in. Well, they did put money in, and they worked hard to get that money. And so you need to respect people's money, understand that they entitles them to some rights, and if you remember that in the back of your mind, I think you'll do pretty good. You know, you'll see there, I talk about targeting old ladies' pensions and Thanksgiving dinner companions for money. Not everybody should invest. This is risky. Not everybody should be doing this. And so, you know, I use the Thanksgiving dinner test, which is if your family member loses everything they put in this, how will Thanksgiving dinner go? If they can't afford it and it's going to be really uncomfortable, you shouldn't take their money. You know, you only take people's money who can really afford this. Poison the company. We talked about making sure you have enough money for management going forward. Make sure there's that. And too many veto rights, right of first refusal, exclusivity, all those kinds of things that will poison the company in the future and give contract rights. Everybody underestimates the cost and time. So, you know, just be realistic about, when I'm talking about this, the cost and time of getting things done, how much capital it'll require. Everybody thinks that it's going to do it quickly. Everybody has their own multiplication. I always think it's going to take, I always think things are going to take shorter and less expensive. And it's always, you know, I have like a 10 times multiple. Hopefully you have less, but make it be realistic. Leave the number somebody else. I do want to pause there. This equity thing and how much you're getting and convertible debt and all that, it's really confusing. But you need to understand that. You know, it's so funny, you spend a lot of time working on the widget, working on the software, working on the drug, all that stuff. And the big picture is how much of this company you own, you won't understand. You need to understand that. Anybody who does convertible debt or preferred stock without understanding the cap table and looking to see what the conversion means upon the convertible debt is making a mistake. You need to do it.
So David, we have 5 law students on the this call, so you want to give them your little lecture about?
Yeah, so I always joke that if you went to law school because you don't like to do math, get over it. You have to do math if you're going to do this kind of work. You have to get out the Excel sheet and spreadsheet, learn how to do it, and do the math. For the business people who think that this is all lawyer stuff, get over it as well. You need to understand these cap charts and understand this thing as well as the lawyers do. You can't rely on them. So both of you get over it.
Well, I'm going to add one little add in there too. This is why one of the big mistakes people make is they don't get a lawyer that specializes in startups. Let us say you have a litigation attorney, or you have one that just does sort of general corporate contracts. So I'm just going to make a plug that this is a specialty type of thing, and I've actually seen people go after a friend, a family, a relative because they think, oh, they can incorporate and they can get it cheap. Don't do that. There's too much at stake.
Yeah, I agree with that. And regardless of, I'm not, this is no push for I don't care. But the point is, I think that Edgar Snyder is brilliant. I wish I had done what he did, but I wouldn't hire him to do this work. And so, to your point is exactly where there are tricks and there's some mistakes, and we just don't want to do it. I already talked about undercapitalizing, ignoring securities laws, so don't do those either. Okay, let me take a moment and take final questions.
David, I just have a question related to safes. You went past it and didn't really talk about pros and cons, but I know some people seem very negative about them. What's the downside of them?
Well, I find I'm not a big fan. The biggest downside is I'm not sure that it's crisp on what they really are. You know, I'm not 100% comfortable what it looks like on a balance sheet because it's sort of a quasi obligation, but it's not a real obligation.
Right.
So is it a debt or isn't it a debt? It's never been quite crisp to me. So I don't love that part of it. I'm also never quite sure on sort of the, what else don't I love about it? That's the principal reason. You know, I find that convertible notes are more crisp on exactly what happens, and you know exactly what you're in for. I'm sorry.
I was just going to say, David, for those reasons, Blue Tree doesn't invest in safes because of lack of specificity or clarity. And then also, just as an FYI to the entrepreneurs on the call, Blue Tree also doesn't invest in common stock. We only invest in preferred.
Right. And that's been the trend for the last number of years, heading towards the preferred. In the old days, when I started doing this, the angels all did common, and now they don't. So that's exactly. I mean, that's my issue with the safe. It's just not. I'm a lawyer, and I like crisp, and I like to know exactly what the client, what the investor's getting, and what the company's getting. And the safe, it's just not crisp to me at all. But it's been, you know, it's been some of the incubators and or accelerators, particularly on the West Coast, began that, and so it's. I can't tell you it's not unusual in certain areas.
Yeah, one of the advantages, which now you're telling me, it's really switched because they were not there was no interest part of it, and saying because that could really that kind of complicated. But now it sounds like that you're seeing more with interest than you are without. Y Combinator started it, and that was their big argument.
Yep.
No,
and you know, yep. And you know, because arguably you don't need it for tax reasons. You don't need it because it's not really a note. For a convertible note, you have to have it for tax reasons. Of course, in today's world, the required amount is the AFR rate, which is, you know, at this very moment 0.17%. So who cares? So it doesn't really. It's not a major issue, at least in this environment. But you know, there's all other kinds of things negotiated in there too, as for example, how much is paid when if there's a sale of the company, and I mean, you end up with some of the same negotiations.
Okay, so while you're thinking of your last questions, I'm just going to make a plug for our next Start Smart. I think it's October 22nd. And on this one, what you're actually going to be done, we're going to be distributing a term sheet. It'll be convertible debt. And what we will do is divide the room in two, and arbitrarily you'll either be the investor or you will be the startup. And you'll have a lawyer with you in each of the rooms, and we're going to decide which of the terms we're going to keep and which are the ones, because with David, he's kind of listing them all out, but it's sometimes you give on one in exchange for getting on another. And so part of what your deal is figuring out which ones really matter to you. So it's a lot of fun, by the way. The lawyers do kind of take jabs at themselves sometimes and make all sorts of kind of comments. After you negotiate, we look for a volunteer who will be the CEO of the company, will actually go into the room with the lawyer, and then you can do as much or as little as you want. And just hear how it goes, and you get a lot of asides about here's why we're not going to give that up. So you do have to register for this, obviously. So David, do you want to add anything else on there?
No, I think it's a good description. It's fun.
Okay, so more questions, because I know I'm looking, we're a couple minutes past our closing time. Again, shortly, don't look right away. The presentation will be posted. And the tape recording will be found on the CMU website. We might be able, oh, Tiffany just put into the into chat to how to register for the next Start Smart if you want to participate. So the recording will be on a YouTube channel you can find on the Short Center website. Any more questions? Just either unmute or you can do something in chat.
Thank you, David.
Going,
my pleasure. Thank you.
gone.
Gone.
Okay, so
All right, team.
Great presentation, David. So
Well, thank you. Thank you.
Before you leave, I just came up with a question.
Yes.
What kind of like when this is investor to a company, would it be different when you do like a joint venture or another type of a relationship?
So that's a good question. A joint venture is a pretty broad term. Which encompass anything. There's contractual ones. There's a separate entity. There's two things coming together to do a joint venture. But many of the issues that we've addressed you have to address the same thing. For example, if somebody's investing in a joint venture, you got to tell them how much, what kind of equity they're getting. You got to still comply with the securities laws we talked about. You still got to worry about. So a lot of the things we talked about would apply just very similarly to an investment into a joint venture. Very similar.
What if the money come from outside the U.S.?
Again, similar issues. The securities laws are different because you'll be relying on what's called Reg S. And so the securities laws are different and the tax implications are different. But putting that aside, the other considerations as to the type of security, the control issues are all similar. But you have issues regarding tax, securities, and depending on where the investment is coming from and the role that they have, you have some other regulatory issues, including CFIUS now, which I forget what the initials are for, but perhaps some disclosure to the government. So there's regulatory issues that one has to think about too if you have foreign investors.
Thank you.
Okay, so round of applause for David here, and thank you very much. And hopefully we will see you on the next show. Oh, good. People are giving you claps. So okay.
All right, thank you.
Thank
you all.
Okay.
Bye-bye.
See ya. Bye bye.